What is standing? Standing is a plaintiff's right to file a lawsuit in court. The plaintiff must have a stake in the outcome in order to have standing. The plaintiff can't just be, an interested member of the public. A plaintiff can demonstrate a stake in the outcome by showing that, for example, the plaintiff has connection to the lawsuit. The plaintiff must demonstrate standing through the petition. A petition is, of course, the first document that the plaintiff files with the court. In the petition, the plaintiff must state, among other things, the factual and legal basis for his or her lawsuit. The plaintiff must mention these three things at a minimum: injury, causation, and remedy. Let's talk about injury first. The plaintiff must show that he has been injured by the defendant or that he could be injured by something that the defendant plans to do. In a personal injury case, the injury could be physical, mental, or even financial. Physical injury could be shown through injuries established by medical bills. Mental injury, on the other hand, could be shown through therapist records or testimony. And then financial injury could be shown through proof of lost wages or damages to a vehicle. Now, on to causation. The plaintiff has to show that there is actually a connection between the defendant's action and the plaintiff's injury. Finally, remedy. In order for the plaintiff to have standing, the court must be able to address the situation. This means that there must be a remedy available to the plaintiff. The remedy could be an injunction, it could be damages, it could be a number of things. The defendant will often file either a motion to dismiss or address the standing issue in an answer if he or she believes that the plaintiff lacks the standing to bring the lawsuit. The court will typically dismiss the case if it believes that the plaintiff does not have standing. There are a few general situations where courts have determined that the plaintiff lacks standing. The first is the plaintiff is attempting to sue on behalf of a third party that was injured. Now, one exception to this example is parents can sue on behalf of their children. A second, the plaintiff is not a member of the group that the law was designed to protect. And then a third that we often see is the plaintiff attempts to sue on behalf of a large group who could have been injured or could have not been injured. If you got any more questions about legal issues like negligence, causation, respondeat superior, anything like that, feel free to check out our other blogs at warriorsforjustice.com. Thanks.